from Charlotte, North Carolina. Stand and wave your hand real high so we can see you. There you go. Al Butler from Wilmington, sponsored by Senator Lee. We have Mason Menning from Raleigh, sponsored by Senator Grafstein. We have Mackenzie Moran Bates, sponsored by Senator Krovic. That name sounds familiar. We have a handful of bills on for today. We're going to start with House Bill 125, NC Health and Human Services Workforce Act. Senator Solry to explain the bill. And before he gets to the podium, Senator Solry actually has an amendment. He's going to move to amend the bill. There was an amendment that he did last week that was H125-ATG-51 version 12. He's actually amending that amendment with amendment H125-ATG-62 version 1. Is that correct, Senator Solry?
Mr. Chairman, that is correct. I actually have two amendments.
Well, let's start with that one.
Okay, the first amendment, and I believe you have a copy of it. This is a simple amendment that changes the effective date in section 2.1C of the bill.
Okay, any questions about the amendment? Anyone wish to? Okay, we have a motion for favorable as to the amendment. All in favor, say aye. All opposed? Chairman Newton is opposed, for the record. Amendment passes. Bill is back before us, and we have a second amendment.
Thank you, Mr. Chair. This is H125-ATG-62V3. If there are any questions about this amendment, I'm going to defer to Mr. Patterson on staff. This amendment simply corrects some typos and hanging sentences that were made, I believe, that were supposed to be included in the initial portion of the collaborative pharmacy practice provision of the bill.
Okay, any questions or comments about the amendment? I have a motion favorable from Senator Lazar on the amendment. All in favor, say aye. All opposed? The ayes have it. Bill is back before us as amended. Again, this was in committee last week for discussion only. Back before us again today. Any questions or comments from any committee members about House Bill 125? Anyone from the audience? No one has signed up. So those were two amendments. So he's good. Yep, we sure did. Any questions or comments from other members of the committee about the bill as amended? Okay, Senator Lazar moves for favorable report to the PCS to House Bill 125 as amended, rolled into a new PCS with a serial referral to rules. All in favor, say aye. Aye. All opposed? I'm sorry, a referral to finance. Ayes have it. Thank you, Senator Solry. We're going to skip ahead to House Bill 471. Representative Riddell.
Thank the chair. Friends, this is an agency bill at request of the state auditor's office. It does several things by way of clarifying that occupational licensing boards, including the materials and operations, are subject to the audit. It also goes on to make some definitions to establish that certain audit work papers are kept confidential, and a few other things recommended by the state auditor. We had this go through state government, I believe, without any opposition, and some good questions.
Thank you, Representative Riddell. I believe Senator Daniel has an amendment. Senator Daniel.
Thank you, Mr. Chair. I do have an amendment. I'm trying to find the number. So I believe it's 471-ATG-57 version 1. This amendment just makes the bill consistent with Senate Bill 80 that was passed out of the Senate and sent to the House. And staff can answer more detailed questions if they need.
Any questions or comments about the amendment? Okay, hearing none. All in favor of the amendment indicate by saying aye. Aye. All opposed? The ayes have it. House Bill 471 is back before us as amended. Are there any questions or comments from members of the committee? Hearing none, have motion for a favorable report from Senator Overcash. All in favor, say aye. Aye. And that is motion for favorable report to House Bill 471 as amended, rolled into a new PCS, unfavorable as the original bill with a serial referral to rules. Is that correct? And all in favor say aye. Once again, all opposed, the ayes have it. Thank you, Representative Riddell.
We thank you too.
Next up, we have House Bill 542, Senator Johnson and Representative Lou, and I believe this has two amendments. One amendment. Two. If I can handle the amendments first. Senator Overcash, you have one amendment. It appears you're moving to amend the bill. The amendment's titled H542-ATG-65. If you could please explain the amendment.
Yes, Mr. Chairman, this makes some changes to the amount of funds that assessments are permitted to do, and makes a couple of other changes. I would actually refer to the bill sponsor for further explanation.
Senator Johnson.
Thank you, Mr. Chair. Thank you, Senator Overcash, for the amendment. The amendment does a couple of things. Representative Lou sent us a great bill from the House, and her bill, it required $2,500 or a year's worth of HOA fees or fines, whichever is lesser. We're going to change that down to $1,500 in this bill, hopefully to make it a little more palatable. In addition to that, we have rolled our HOA transparency bill that we passed the Senate unanimously earlier in the year. We're rolling that piece into this. We're adding two other pieces to it. One states that HOA management companies would not have the ability to collect a percentage of fines. So if a management company or if a fine is levied on an HOA member for grass or something like that, that money would go to the HOA, not and a percentage of that could not go to the management. So we don't want to incentivize policing of these by a management company. So we're taking that piece out. It's been told to me that that doesn't happen anyways, but I've got some other folks have cited that this does happen. So we just want to clear it up and make sure that that's not going on. Lastly, we want to make sure that HOAs can manage roads that are privately owned. And so if the HOA or a private group owns the roads, they can manage the roads. But if it's a state or municipal road, that would fall to the state or to the specific municipality for policing those roads and managing who can park on them and where they can park. Would appreciate your support for the amendment.
Any questions or comments about the amendment? Senator Marcus and then Senator.
Just one quick one. Senator Johnson, you mentioned the change in the amount of dollars, and then it's whichever is lesser, right? So you said this makes it more palatable. Do you mean for the homeowners association? Okay, so because the result of this will be that homeowners will more quickly have a lien put on their property, correct?
That's true.
Mr. Chair, I would like to be acknowledged to answer the question.
Representative Flew.
Thank you. Initially, we had the bill was drafted as the lien has to be 1 year or $2,500, whichever is greater. But based on the feedback from the HOA community, they really didn't want their capacity to be limited for collecting their dues. So we changed it to whichever is lesser. Then we further reduced it to $1,500 to accommodate the HOA community for their concerns about not being able to collect the fees that are due.
Mr. Chair, I'll add one comment to that.
Senator Johnson.
Senator Marcus, so today, if there's a $20 grass cutting fee, that can be levied today. And so the problem we're trying to address is a closing a property, maybe a tenant occupied home that the owner of the property may not know about, and they go to sell this property, they get to a closing on a $500,000 house or a condo or something, and it's held up by a $20 fine that was not paid. So we don't want these to be liened unless it's $1,500 or more. And we put the 12 years or 12 months or less because there's some HOAs their dues may only be $25 a month. So, but they're still a year in arrears. So we want to make sure that folks are paying their dues as well. We want to make sure that people aren't skipping out on paying their dues. So that's why we reduce that amount. But if you don't like that and you want to go back to 2,500, I'm fine with that too.
Thank you for the explanation. Appreciate it.
Senator Grassley.
Thanks. I actually had the same question, but I'll take this time then to just do a follow-up on that. I wonder, I guess, if there's any analysis that anybody can offer about how many foreclosures this might save, and maybe that's too hard to figure out given these are private entities. But I also wonder if there's a way to decouple maybe making sure people are paying their dues from the whole foreclosure piece of it, because I think part of what certainly I've heard, I'm sure other people have heard from folks who they go into foreclosure on something that is a disputed fee, and it becomes a nightmare for them. So I wonder if there's any consideration given to an ability to assess and collect the fees without having to put a lien and then go or at least stop the lien at the point of foreclosure, if you know what I'm saying.
Thank you, Mr. Chair.
So currently, our state does allow HOA foreclosures. I believe there's a bill on the Senate side that to get rid of HOA foreclosure completely. Not every state allows HOA foreclosures, and we've heard many horror stories that citizens just are being really upset that the homes are foreclosed on for a few $100. And so our bill is a first step to address this issue. So we extend the time period for homeowners to be aware of the liens on their property, and to create a minimum threshold before a lien can be filed. So this is a good step towards the right direction.
Thank you, Representative Blue. I appreciate that. And one follow-up.
Follow-up, Senator Grassley.
Yes, so Senator Johnson, I assume that was an invitation then for us to amend this bill also to add the Senate version that would prohibit the foreclosures at the outset.
Take it under consideration. I'm not familiar with that particular bill.
Any other questions or comments about the amendment? And again, this is the amendment only. So the amendment, H542-ATG-65 is what's before us. We have a motion for Senator Overcash to amend the bill. All in favor, say aye. Aye. All opposed? The ayes have it. The amendment is approved. We have another amendment from Senator Sawry. It is on your desk. It is titled H542-ATG-66. Senator Sawry to explain the amendment.
Thank you, Mr. Chair. This is a simple amendment. It's a friendly amendment. Some HOAs or some restrictive covenants may contain a provision that prohibits the conduct of home businesses or other services on the property that are subject to those restrictions. This simply amends that to prohibit restrictive covenants or an HOA from fining people that are operating things like music lessons or swim lessons on their property. As I explained to Senator Johnson, I believe that, we have a dearth of musical literacy in the United States, and we need to encourage that and do not need to let HOA stand in the way of that from happening. And swimming is something we should encourage as well. So we do not need HOAs abutting in traditional Americana with swim lessons and music lessons. This is friendly. I commend and ask for your support.
Any further explanation on the amendment, Senator Johnson?
Mr. Chair, just to reiterate, this is a friendly amendment, would encourage committee support.
Any questions or comments from members of the committee on the amendment? Senator Daniel.
Well, I would just say this is why it's better to live on a farm and not have to worry about other people managing your business.
Let's second that. No other questions or comments about the amendment. Senator Sawry moves to amend the bill. All in favor, say aye. Aye. All opposed? The ayes have it. House Bill 542 is back before us as amended. Senator Johnson, any further discussion on House Bill 542?
That's all. Mr. Chair, would just like to thank Representative Blue for the help on this bill. Thank you.
Thank you. We do have one person who has signed up to speak on House Bill 542. Mr. Weldon Jones, you could come up, give your name and who you are with.
Thank you, Mr. Chairman. Weldon Jones, members of the committee. I represent CAI, the Community Association Institute. For all intents and purposes, CAI is just a trade group of HOAs. Senator Daniel, we have equestrian communities that are encumbered by covenants. We have urban communities. We have the whole gamut of HOAs in this state. Senator Liu, we appreciate being able to work with you and Senator Johnson on this bill. However, CAI still has very, very serious concerns with the bill. I can't speak too much to the bill as amended. I haven't seen the amendment. I talked with a few folks about the road amendment, and Senator Johnson, we worked on your bill with management contracts. Those are pieces I think we can support. However, a lot of this bill is making sweeping changes to the laws of associations and condominiums in this state. We would just urge your support for further study and perhaps working on some of these things in the off session to try to maybe get some of these ideas on paper in a way that they can be palatable to all interests. Because as drafted right now, the bill really has two provisions that we have concerns with: the assessment piece and the notice piece. So the notice piece of the bill is something that hadn't been talked about, but one of the changes to statute being made is that this bill would require that folks that are in arrears be contacted by email and by phone. So, the federal government has already told us by way of the Fair Debt Collection Practices Act that you've only got limited means to contact debtors, right? You can't do it before 8, after 9, during work, using their work email. So this bill sets associations, really the volunteer board members, your constituents that serve on those boards, it sets them up for pitfalls under the Fair Debt Collection Practices Act for violations. As to the assessment
All right,
threshold.
thank you so much. We appreciate your comments.
Okay, all right. Thank you, members of the committee. Happy to answer any questions.
Next, I think Representative Iler is also on the bill and wants to address some of the comments.
Thank you, Mr. Chair. And for information, there's a study bill out there, but it hasn't come through yet. It's got my name on it. But I obviously support this bill. There's almost 3 million people in North Carolina living under HOAs, and 14,000 of them, I understand, from the group. So it's like a local government. Your dues are your taxes, and the board has like many powers. So I think we need to take another look at it, and this bill is a good start. Thank you.
Thank you, Representative Iler. And I forgot to mention earlier, this bill is on for discussion only. It'll be back in committee on Thursday. If someone was maybe not as concise as what they would have liked to be and maybe miss some of their points, they can come back Thursday and make those points. Any other questions or comments from members of the committee? If not, we'll move on.
Mr. Chair. Just a quick
Senator
question.
Solry.
Thank you. This is probably for staff, but are HOAs covered by as debt collectors in the Fair Debt Collection Practices Act?
It's going to be staff. Mr. Patterson.
Yeah, I think it depends a little bit on whether they are collecting the debt themselves or have contracted with someone else to do that. But I'll have to do some further research to get the details on that, Senator.
Thank you.
Thank you, Senator Johnson, Representative Iler, and Representative Liu. Next, we have House Bill 790, Representative Pyrtle to explain the bill. And there is an amendment. Is this it?
Thank you, Mr. Chairman.
Mr. Chair, I'd like to move to amend the bill.
Senator Daniel moves to amend the bill.
So the amendment number is 790 ACE 79 version 6. And what the amendment does, it has some technical corrections the staff identified. It updates the reporting requirements of the Innocence Inquiry Commission as requested by the commission. The amendment also adds in the contents of Senate Bill 640, which was entitled Various Criminal Procedure Changes. This bill passed the Senate unanimously. Just to recap what that bill did, it modifies GS 15A-211 so that electronic recording requirements would be applicable to the following: all law enforcement interviews and custodial interrogations of juveniles in criminal investigations when conducted at a place of detention, all law enforcement interviews and custodial interrogations of any person in a felony criminal investigation conducted at a place of detention. Also requires the crime lab to adopt procedures for notifying indigent defense services of post-conviction CODIS hits that are exculpatory in nature. And so I commend the amendment to you. That's what it does.
Any questions or comments about the amendment? Hearing none, Senator Muhammad moves for a favorable report to our moves favorable to the amendment. All in favor say aye. Aye. All opposed? The ayes have it. House Bill 790 is back before us as amended. We do have some people signed up from the audience to speak. Does anyone on the committee have any questions or comments about House Bill 790 before I hear from the audience? Representative Pyrtle, do you have any additional information about House Bill 790 to add for committee?
I think you've covered it well.
Senator Marcus.
I do have a question, Mr. Chair. I do hope someone from the Innocence Inquiry Commission is here to speak on the bill. My question would be, what is the need for the changes? Is there some sense that the commission has been finding people to be innocent wrongly in some way, or why are we changing the way in which they're currently operating?
And we do have folks from Innocence Inquiry Commission signed up to speak, as well as NCAJ and Conference of DAs. Being no more questions or comments.
Can I get an answer to my question?
Yeah, what was your question?
Why are we changing is the way that the commission
Representative Pyrtle.
has
Thank
been
you.
operating?
Thank you, Mr. Chairman. Thank you for the question. This come as a result of conversation with district attorneys across the state, also members of or the Conference of District Attorney, and conversation with members of the Innocence Inquiry Commission. Basically, these provisions that's listed in here just level the playing field and provide that as early as possible, district attorneys confronted with new evidence that provides innocence or that undermines the evidence that was relied upon for the conviction can act to see that defendant's case is resolved appropriately. It's just given the district attorneys a leveling the playing field for the district attorneys. And when that was brought to me, first thing I did was discuss with the district attorneys and Innocence Inquiry Commission about some of the concerns within the statute that they had.
Senator Marcus.
Just follow up. I'm not sure what you mean by level playing field, but maybe if we hear from the folks who you referenced, that will help. I'll drop it for now. Thanks.
Thank you.
Any other questions or comments? If not, first I have Corrine Fowler, signed up from North Carolina Innocence Commission.
Good morning and thank you. My name is Corinne Fowler and I am a staff attorney with the North Carolina Innocence Inquiry Commission. Our executive director, Lindsay Geis-Smith, is unable to be here today, so she asked me to pass along a brief message about this bill. When the commission was first alerted to this bill, the commission did not support the bill as it was originally drafted. However, since then, the commission has worked with the Conference of District Attorneys, Representative Pyrtle, and several other legislative members on the portions of this bill that directly affect the day-to-day operations of the commission. The commission is of the opinion that a good compromise has been accomplished on these said portions of the bill. With that said, the commission is not taking a position on the portions of this bill that affect the 3-judge panel, as those are outside the scope of the commission's day-to-day operations. I'm available to answer any questions. Thank you.
Senator Marcus, would you like to ask your question of the commission?
Yes, if I could, Mr. Chair.
Yes, ma'am.
Ms. Fowler, thank you for being here. You said you're not taking a position on the 3-judge panel because it doesn't directly impact what you do. Could you explain to us your understanding of what it will impact? So we all can understand that process as well.
So thank you for the question, Senator Marcus. The commission process it starts when a case comes to us, somebody applies to the agency, it gets assigned to a staff attorney, and we completely investigate it. If there's grounds for verifiable, credible evidence, we present that to our commissioners, who then vote whether or not they find innocence. Since then, or from that point, then it gets transferred to a 3-judge panel. At that transfer, it is no longer in the commission's process. The commission has no say on what happens at the 3-judge panel. We're not involved in it in any way. We transfer all of our information over to the claimant's counsel and the DA that's involved. And from that point forward, what they do with the case is kind of in their court. So that's why the commission does not take a position on those portions.
Senator Marcus, any follow-up or are you good?
Not right now.
Senator Muhammad.
Thank you. Thank you, Mr. Chair. Just had a question for the representative. Can you speak to a little bit about how those 3 judges are appointed?
Sure. So the 3 judges are appointed, I believe, and I'm new to the commission-ish, so I'm still learning all of things. the 3 judges are appointed based on the chief judge. I think they're based in the district where the case was originally from. Does that answer? Yes. Yeah. Good.
Any other questions or comments? If not, next up we have Brad Bannon from North Carolina Advocates for Justice.
Thank you, sir. Thank you, Mr. Chairman. My name's Brad Bannon. I'm a past president of North Carolina Advocates for Justice, and I represent innocence claimants before the North Carolina Innocence Inquiry Commission process. I'm speaking solely to the 3-judge panel provision of the statute. Oh, I'm sorry. I'm speaking solely to the 3-judge panel provision of the statute upon which the District Attorney's Conference and the defense bar have reached agreement about pre-hearing disclosures, which I think Mr. Spayos will provide that language when he speaks. I'm speaking about the application of the rules of evidence to the 3-judge panel hearing. To Senator Marcus's question, the Chief Justice of the Supreme Court appoints the 3 judges who hear it, and it doesn't necessarily have to be from the district where the original case was heard. The reason those 3 fact finders are appointed by the Chief Justice is because there's already a standard of evidence of credible, verifiable, relevant evidence that the panel should hear to determine innocence. That's a very high burden. If the rules of evidence were made to apply at this stage, they would extraordinarily lengthen both the pre-hearing process and the hearing process itself. I tried one of these last year that would have lasted 4 to 8 weeks instead of the 1.5 weeks that it took. And of course, the people who would actually hear those legal challenges would be the judges who would be hearing the evidence themselves. So really, it's sort of a diminishing returns issue. And I think to my final point of the 17 claims of innocence that were actually presented at the hearing, 9 claimants were granted relief, 8 claimants were not. Of the 12 claims of innocence that the state contested, 4 claimants were granted relief and 8 claimants were not. So there is no evidence of any disparity of outcomes here. And to the extent there is, the state has prevailed in its position 2-1 in terms of hearings when they occurred. So it'd be my request on behalf of claimants to remove that language, let this process continue the way it has, and in a manner in which no issues have been identified up to this point. And I'd be glad to accept any questions from anybody.
Senator Marcus.
Thank you. If I could ask Mr. Bannon to remind us why we have the rules of evidence in place in a jury setting and why that wouldn't apply here. I think you touched on that, but could you underline that for us?
Certainly. At a jury, lay people are fact finders, and they don't understand necessarily the nuances between what evidence is relevant and what evidence isn't. Here, the Chief Justice appoints 3 judges who have spent their professional lifetimes assessing credibility and determining whether evidence should come in and be considered. And that was sort of the whole point of appointing 3 judges from the Chief Justice, was so that we would get past the issue of rules of evidence and sort of get past the gamesmanship that's often deployed by both sides in an adversarial setting under those, and to get to the heart of the issue, which is this person innocent and do they deserve relief? And we know, of course, that many claimants have been given relief since the institution of this process, oftentimes with the consent of the state after the Innocence Commission has done its investigation and process.
Follow-up, Senator Marcus.
One follow-up, maybe Mr. Bannon can answer this as well. Does this change in any way the burden to show that the defendant is actually innocent as opposed to just not guilty under the law?
No. This is not some technical burden here. The claimant has to prove by clear and convincing evidence that they're innocent. And in order to even get to that space in the process, the claimant has to waive all of their rights to rights against self-incrimination, attorney-client privilege. They have to open themselves entirely up. They have absolutely no involvement in the commission process itself, whereas the state does. They do have some advocacy that they can deploy in that process. The defendant doesn't. So by the time we get to a 3-judge panel hearing, the defendant has to prove to 3 judges appointed by the Chief Justice by clear and convincing evidence they're innocent. It's a very high burden to meet.
Senator Muhammad.
Thank you, Mr. Chair. Can you speak up? far as the three-judge panel, that's my understanding as it currently is, they have to find unanimously conviction was wrongful.
If I heard correctly on my hearings,
It has to be, it
52.
has to be a unanimous decision of the three-judge panel.
Yeah, oh, absolutely. That all three of the judges have to agree that the claimant has proved their innocence claim by clear and convincing evidence in order for the claim to be granted.
And again, from your experience, these judges that are appointed to this panel, they're appointed by the Chief Justice. They're generally well-experienced, knowledgeable judges.
Absolutely, yeah.
Okay, thank you, sir.
Any other questions or comments from members of the committee?
For the sponsor.
Senator Muhammad.
Thank you, Representative, for being here today and for your bill. So based on what I'm hearing from the from the folks that are here speaking on behalf of the bill today, if we have experienced judges who are appointed by the Chief Justice, in this case, Justice Newby, they're well-experienced judges. They're not lay people, as the speaker said. They understand the rules of evidence. Here we're looking at a significant inquiry. Senator Newton just shared with me, there's been 15 exonerations out of 3,000 applicants. So very few folks even get exonerated. Why do we need to make such a drastic change in something that works well right now?
And we also have another member to speak from the audience too. But
Let him speak first.
Representative Pyrtle.
That's my question. If it's working well right now, why do we need to make the change?
Well, I think North Carolina has one of the broadest collateral challenges to convictions in the country. And the three-judge panel can set aside a jury decision or a judge's sentence. And to allow this power on the evidence that would not be admissible in trial court is, would be a miscarriage of justice. If it's allowable, or put it this way, if to not allow, or to allow this power to rely on the evidence that would not be admissible in trial court is I just don't agree with.
Follow up.
And follow up, Senator Muhammad, we also have Chuck Spahos from the Conference of DAs to address your questions.
Representative, don't you think it would also be a miscarriage of justice if an innocent person is potentially convicted, potentially serving a life sentence? And now this is an opportunity for well-experienced, seasoned judges who are appointed again by the Chief Justice of the North Carolina Supreme Court to review this. They have to exonerate this individual by a unanimous decision. Looks like there's a thorough vetting of that process. So why would we potentially want to keep an individual that might have been wrongfully convicted? Would that not be a miscarriage of justice?
Representative Pyrtle.
Thank you, Mr. Chairman. Having spent 30 years in law enforcement and as an investigator, I always think it's a miscarriage of justice that any innocent person go to jail. And when I investigated cases, when I found someone that during the course of my investigation, it was just important for me to prove that this person that did it is the only one that could have done it. And I also followed up on any leads. So yes, I agree with you. However, I have complete confidence in my discussions with the Innocence Inquiry Commission on the performance of what they do. And I just think that when it gets to the three-judge panel, that the rules should be at the same as it was at the trial court. If they have the ability to overthrow a decision of a jury of our peers and the sentence of a judge. It's just a disagreement on what we think, but thank you.
Mr. Spahos, could you state who you are and who you're with?
Thank you, Mr. Chairman. Chuck Spahos with the Conference of District Attorneys. We do support the bill. I'm going to narrow my remarks to the rules of evidence at the three-judge panel because that appears to be the point of contention. North Carolina does have, if not the broadest, one of the broadest collateral assaults on convictions in this country. And we're not here trying to undermine that or do away with the commission. What we are saying is we need to create consistency at the three-judge panel. Most of the judges that have sat in three-judge panels do apply the rules of evidence. However, that is not clear and it is not required by statute. And what we're saying is we believe, the state believes, that if you're going to undermine the jury's verdict and the judge's sentence, then you should do it with admissible evidence. Rules of evidence are about authenticating the evidence, about establishing its reliability, and about having confidence in the evidence. That's what it's about. That's why we don't try people and convict people on triple hearsay, or why we require documents to be authenticated and otherwise. And this provision simply says if you're going to, three-judge panel is going to set aside a verdict, that they should apply the rules of evidence and do it consistently every time there's a three-judge panel. I'll be glad to take any questions.
Questions, Senator Marcus and then Senator Muhammad.
Thank you, Mr. Chair. What if part of, Mr. Spehouse, what if part of the miscarriage of justice was the decision on whether or how the rules of evidence were applied? What if that's the part or all of the reason why an innocent person is in jail, is in prison?
I'm not sure I follow your question. What would be the miscarriage of letting somebody out of jail I'm sorry, then.
No, I'll try again. You said you want to apply the rules of evidence, keep out any evidence that the trial court said was inadmissible under the rules of evidence. That, which would be, I'll say as an aside, to protect the jury from hearing things the jury shouldn't hear. But what if that was the miscarriage of justice? The innocence inquiry is all about remedying a miscarriage of justice that put an innocent person in prison. And so I feel like what this bill's doing is keeping in place some of the ways in which justice was miscarried by wrongfully keeping out evidence that an experienced three-judge panel that has to vote unanimously would be able to assess for themselves.
Okay, yes, ma'am. I think I follow your question. Remember, we're not talking about an appeal, and remember, we're not talking about an MAR. This is the third method of collaterally attack. It's usually based on some new evidence or some evidence that wasn't available at the time. So it's not about evidence that has previously been ruled inadmissible based on rules of evidence. It's about, and what this provision is about, is whatever evidence is now being placed in front of that three-judge panel have some value. That's what the rules of evidence are about. It's about the value of the evidence and a proper foundation for that.
Mr. Chairman,
Yeah, Chairman Newton.
Thank you, Mr. Chairman. Mr. Spehouse, I'll make sure I understood this colloquy and questions that's been going on. We just want to make sure that the new evidence that's being put forward to the three-judge panel is evidence that's competent under the rules of evidence, right? I mean, that's basically what we're talking about. Is that right?
That's exactly what we're talking about.
Okay, thank you.
Senator Muhammad.
Oh, I can't hear.
Mr. Spehouse, is it?
Senator Muhammad, would you mind speaking in your mic so we can hear you too?
Sure.
Thank you.
Trying to be respectful of our guests as well. Mr. Spehouse, aren't there other hearings that judges undertake that don't always follow the rules of evidence?
There are preliminary, are there times in our court system that rules of evidence are not found, certainly. And there's some preliminary matters that are held that often say hearsay is available. But that's not being used to convict or undo a conviction. There's times when information goes into a search warrant affidavit. Again, a preliminary investigation thing that might not be admissible under the rules of evidence, but is admissible for that. But those are all preliminary matters.
So, for example, what about probationary hearings? Aren't the rules of evidence much more loose for a probation hearing, for example?
They certainly, the probation hearings are much loose. Most of the time, those are about allegations of a new offense, or the testimony is of the probation officer about failure to report or otherwise. It is a different procedure.
And in a for example, probation hearing, the hearing's only by one judge, correct? It's not a jury or anything like that conducting that hearing.
That's correct. That's been my experience.
All right. Thank you, Mr. Spehouse. Appreciate it.
Thank you, Mr. Chairman.
Thank you. I've got, did you say, okay. Senator Marcus.
I'll try this backward approach too. I'm trying to figure out if the Conference of DAs disputes the 9 people in the history of the commission that have been granted relief. Was there some problem in the way the judges, the 3-judge panel decided those cases that would justify this change in evidentiary rules?
No, what we're trying to do is create consistency so that the 3-judge panels do equally at every time there is a hearing, apply the same rules.
Follow up?
Follow up, Senator Marcus.
So we agree that to date, the 3-judge panels have been operating appropriately.
I'm not aware of a particular panel that I could contest today. that's what you're asking me.
Okay, thank you.
Senator Grasstein.
We're doing a new thing now. Just a short question, and I apologize, I don't know this area real well, but is the Conference of DAs opposed to the existence of the Innocence Commission or this process, or are you supportive of that continuing on into the future?
Yes, ma'am. We're standing here today supporting this process. And in fact, because we got so focused on the rules of evidence, I didn't get to say what I intended to say about the bill itself. We have worked diligently with the commission to expand the periods of time, for instance, that the state has to consider the evidence. Oftentimes these cases, and the reason there's not as many of them as there used to be, is that process leads to an agreement in cases, and the district attorneys can consent to something other than the current conviction, and that the process that we've done in this bill actually expands the ability for the state to consider the evidence, to have a conference ahead of time, and to try to get to the facts and what is proper. So we do believe it's a valid system. We believe these changes make it an even better system, and the DA is the one that is best suited and the one that can get a person out of prison that's not supposed to be in prison the soonest. And that's what this is about.
Thank you, sir.
Okay. Any other questions or comments from committee? If there are none, House Bill 790. We have a favorable report from Senator Newton. Moves for favorable report on House Bill 790 as amended, roll into a new PCS, unfavorable as the original bill with a serial referral to rules. All in favor say aye. Aye. All opposed. The ayes have it. Thank you, Representative Pyrtle. Next up, we have House Bill 145, Senator Todd Johnson. How did we let Todd have two bills today?
He's a nice guy.
Thank you, Mr. Chair. I wouldn't begin to correct you and say that it's a Senate bill, but I appreciate you hearing my bill nonetheless. We do have an amendment on the bill, Mr. Chair, if we could go ahead and hear that. Senator Overcash.
Senator Overcash moves to amend the bill. I believe it's S-145-ATU-37 version 2. Everyone should have it before them. Senator Overcash to explain the amendment.
Yes, thank you, Mr. Chairman. This addresses the Continuing Care Retirement Communities Advisory Committee, and I'd refer to the bill sponsor.
Mr. Chair, if we could
Senator Johnson.
have Kristen Harris explain the amendment.
Ms. Harris.
Kristen Harris, Legislative Analysis. The amendment would change the appointments to the Continuing Care Advisory Committee. The Commissioner of Insurance would appoint 6 of the 12 members. The President Pro Tem would appoint 3, and the Speaker of the House would appoint 3.
Senator Johnson.
Appreciate support of the amendment.
Any questions or comments about the amendment? Senator Grasstein.
I feel like I always just ask this question, why is my question, but so right now as the bill stands, the committee would be 12 members appointed by the commissioner and has other parameters around it that ensure that it's sort of people who are in this community. What's the, I'm, just frankly dubious of having political appointments. That would be half this committee or commission. And I'm wondering what the reason is for changing it from the commissioner to a political body, 2 political bodies.
Senator Johnson.
Thank you for the question, Senator Grafstein. I would say that even as it stands now, they're all political appointments because they're being appointed by the commissioner, who's an elected body or an elected official. We just felt like it would make more sense to have a varying array of folks to serve on this committee because it's a very important issue. And we felt at this point in time, since nothing's been changed on this statute for 20 to 30 years, it would be a good time to get in more folks from different areas to have a say in what goes on.
Senator Grafstein.
Yeah, just surprising no one have concerns about that. You know, in part because it's political in in a different sense. You know, when you have appointments to a commission from a commissioner, that's somebody who's in depth involved in an area. We are really moving at rapid pace to this legislative body overtaking every committee and commission in this state with appointments that are, I would say, outside the scope of expertise, but also that are then reflective of, let's just be frank, whatever political party's in power, they're appointments of that political party. And it just really creates an imbalance that I think has really gotten to the point of overreach. So I would ask that we reconsider whether we really want to go down this road with this particular commission on an issue that I think is really important to a lot of people.
Thank you, Senator Grafstein. Any other questions or comments on House Bill 145? On the amendment to House Bill 145. As to the amendment, all opposed, say aye. I mean, all in favor, say aye. Sorry. All opposed? The ayes have it. House Bill 145 is back before us as amended. Any questions or comments about House Bill 145 or Senate Bill 145? It says it in two different places. Sure. Okay, so again, this is Senate Bill 145, not House Bill 145. The computer made an error whenever it was printing this thing, I believe. Hearing no questions or comments, nobody signed up to speak for or against the bill. Have a motion favorable to Senate Bill 145 as amended, rolled into a new PCS unfavorable as to the original bill with a zero referral to finance by Senator Lazar. All in favor, say aye. Aye. All opposed? The ayes have it, and this meeting is adjourned. We'll meet again on Thursday morning at 10 a.m.